Alright, Federal Road Administration Track Safety Standards Compliance Manual, Chapter 5, Track Safety Standards Class 1 through 5, Office of Safety Assurance Compliance and Track and Structure Divisions. April 1st, 2007. Subpart A, Subpart B, Subpart D, Subpart E, Subpart F, and appendixes. Track Safety Standards Class 1 through 5. The chapter provides necessary information for the FRA inspector to properly apply with the track safety standard during the inspection activities. The term FRA inspector includes all state inspectors that are participation in the federal program. This manual is not to be construed with modification, alteration, or revisions of published track safety standards. Any legal proceeding instituted against the railroad must be based on regulations found in Title 49 CFR Part 213. Inspectors should refer to this manual on the often necessary to understand the intent of the particular rules. They are assuring the extended practicable nationally uniform application of these rules intended for the Congress Federal Railroad Safety Act of 1970. The inspector will not, and under any circumstances, adjust, correct, or repair the track appurtenances not authorized, suggest recommendation of any of the movements over any of the track. Full responsibility of the matter rests with the railroad. The inspector will immediately inform the railroad of any of the track condition not compliance with the track safety standards. The manual is based on the track safety standards published in June 22nd, 1998, in Site 63 FR 33992. The gauge restraint measurement, or GRMS amendments, published in January 10th, 2001. C66 Federal Registry 894. The continuous welded rail, or CWR, final ruling, published in October 11th, 2006. C71 Federal Registry 59677. Inspectors are encouraged to provide suggestions for enhancement in the future editions of this manual. Appendix B contains the defects of each of the subsection regulations. Defect codes are important and analytical tools for the FRA data collection. If the inspector cannot find the defect code corresponding with the violation of the track safety, the inspector may submit the violation of the chapter addressed for the class 1 through 5. Chapter 6 addresses class 6 through 9. This text in the italic font of the manual is regulatory language, whereas independent paragraphs provided with the field guidance of the FRA inspector. Intended paragraphs are not to be construed with regulatory language in any manner. Subpart A, General. 213.1, Scope of the part. The part describes minimum safety requirements of the railroad track that is part of the general railroad system of transportation. The railroad requirements prescribed in this part apply to the specific track conditions existing in isolation. Therefore, the combination of the track conditions, none of the individually amount to deviation from the requirements in this part, may require for remedial action to provide the safe operation over the track. This part does not restrict the railroad from adopting and enforcing additional more stringent requirements or not inconsistent with this part. Guidance. It is more important to notice that the track safety standards and minimum safety requirements are not appropriate with the track maintenance purpose. The section also notes while the track safety standards address specific track conditions that exist in isolation, there are sometimes the combination of track conditions, none of which individually amounts to the deviation of the track safety standards, that require remedial action to provide safe operations over the track. Experience that has shown that such an event occurs only rarely. The inspector should encounter with such a condition. The inspector should immediately bring the condition to the attention of the accompanying railroad official, explain the hazard of such a condition, encourage the rapid removal. While the inspector is not able to convince the railroad to initiate some action, the inspector should refer to the regional track specialist for assistance. Subpart A through F apply to the classes 1 through F, 1 through 5, or Subpart G, 213.2 and 213.3 and 213.15 apply to the track over which the train is or operated speeds in excess of permitted with over the Class 5 track. Guidance and introduction of the high-speed train operations in the nation. The track safety standard was revised in 1998 to provide two sets of requirements: a low-speed class 1 through 5 and a high-speed class 6 through 9. The high-speed standards include specific requirements such as operation, which also prescribe the number of the track vehicle interaction tests. Section 213.2 preemptive effect, 213.3 application, 213.15 penalties apply to both high and low-speed track. 213.2 Preemptive effect. Under the Title 49 U.S. Standard Code 20106, these regulations generally preempt the state law regulations order the covering the same subject matter, except in addition with more stringent law regulation order and necessary to eliminate the reduced and essentially local safety hazard is not incompatible with law regulation order of the United States government that does not impose unreasonable burden on the interstate commerce. Guidance. States cannot adopt or continue to enforce related with the material covered in this rule unless such laws are needed to address the local safety security hazard and they impose new undue burden of interstate commerce, although the courts ultimately determine the preemption in any particular factual context. The section provides a statement of agency intent with the promotes the national uniform regulation according to the statute. 213.3 Application Exception as provided within paragraph B of this section. This part applies to all standard gauge track general railroad system transportation guidance. This applicability section specially excludes the Part 213 track located inside the installation. This is not part of the general railroad system transportation. Additional with the language regarding the plant trackage can also be found in Title 49 CFR Part 209 Appendix A, which explains that the track owner of any plant railroad trackage over the general system railroad operates reasonable for the condition of the track over the general system railroad. Part 209 Appendix A is not meant to imply that all requirements of the track safety standard, including inspection frequencies, record keeping, making, coming applicable to plant railroad once a general system railroad enters into property. It is a statement meaning that convey the FRA's intent that the plant should maintain in a safe condition that a portion of the track should be used in the general system of the railroad. 3B. The part of the does not apply to the track 1 located inside the installation, which is not part of the general railroad system of the transportation 2, the used exclusively for the rapid transit operations of in an urban area that are not connected with the general railroad system transportation. Guidance. The FRA does not have the manpower resources to regularly inspect the trackage with industrial installation. However, since the enactment of the Federal Railroad Safety Act of 1970, the FRA has and had its disposal statutory authority to issue the emergency orders to repair, discontinue, an industrial plant trackage should the FRA find the track conditions to be posed death or injury hazard. See Title 49 U.S. Standard Code 201901. In other words, the FRA learns the particular plant is in such a deep disrepair so that it poses the threat and death of the injury to the plant employee, railroad employee, the public at large. The FRA has the option to exercising the authority with the FRA may issue the emergency order of the plant and to discontinue using the track until the specified repairs are made. The FRA's opinion with that this emergency order is sufficient to put power to ensure the track safety within the plants and condition of the events of the future tend to demonstrate the track safety within the plants and installation should be more regulated. The FRA will seek to change the track safety regulations accordingly. Because it is policy statement Appendix A of the Part 209 cannot override the text of the track safety standards, which clearly excludes the plant railroads from reaching the track regulation. Therefore, the requirements of the track safety standards do not apply with the plant railroad. Those operations should use them as a guide to ensure that the tracks are capable of carrying rail traffic safely. As particular application of this policy, the FRA expects that the trackage in plant railroad at a minimum meets the Class 1 standards that segments for the general system transportation operates in the facility. The FRA does not expect the plant to comply with the inspection requirements, but only on the geometrical structural elements of track safety standards for the Class 1 track. The track safety standards excludes the urban area rapid transit system that are not part of the general system. These regulations are not intended to make the track safety standards applicable to a certain rapid transit system whose only connection to the general system is a switch permitting reset of the shipments of non-revenue materials from the general system. Any questions concerning the applicability of the track safety standards must refer to the regional track specialists who will consult the Office of the Safety Assurance Compliance with the Office of Chief Counsel of Guidance concerning the particular entity. 213.4 Expected track. Track owner may designate a segment of the track as expected with the track provided with the 4A. The segment is identified with the timetable, special instruction, general order, and other appropriate records which are available for the inspection during the regular business hours. Guidance. The intent of this section is to permit the portions of the current, certainly low-density main tracks associated with the yard tracks and sidings to be allowed with the accepted status, not to comply with subpart B, C, D, E, and E of the track safety standards unless they are otherwise express stated. However, by the designated track is expected, the owner must restrict all its movements maximum of 10 miles an hour, restricted the number of the placard hazard materials in train to 5, and prohibit the movement of occupied passenger train. 4B, identified segments is not located within 30 feet of the adjacent track, which can be subject to simultaneously using speed in the excess of 10 miles an hour. Guidance. The paragraph prohibits the accepted track designation of any of the track located within 30 feet of the envelope of the track that can be subject to simultaneously using the spread in excess of 10 miles an hour shown in Figure 1 of the 30 feet dimensions measured between the track center lines and applies to all the tracks within the envelope of the track converging with the turnouts and rail crossings. Simultaneously use the movement of the cars and locomotives operate at the same time. Tracks to operate at the same time. Operation of any of the tracks located within 30 feet accepted from the track may be restricted to 10 miles an hour by the physical layout of the tracks. Define restrictions placed with the track owner in the rule table, timetable, special instruction, other positive instruction, or order the criterion provided with a positive of the protection of the trains higher than speed track against the collision of the following equipment of the potential derailment of accepted track. Figure 1 shows the track greater within 10 miles an hour, 13 feet away from the center of another cannot be expected 10 miles an hour, 26 feet from another track set cannot be put out. But a track greater than 10 miles an hour can go 10 miles an hour at past 39 feet, another 13 at 39 feet, and may be expected. The term train is defined in Title 49 CFR 236-832 as a locomotive with more than one locomotive coupled with or without cars. The finite applies to the rule. The designating accepted the track needed but they only recorded by the track owner, implemented by the issuance of appropriate instruction for all the affected employees. The designated need not to be filed with the FRA. The track safety standards do not specify the employees of the railroad must notify the expected track designation. However, in order to maximize safety to ensure the compliance with the requirements of this part, the FRA recommends the railroad notify all employees who are involved with the operation, training, and the engineering functions at accepted tracks. 4C, identified segments inspected within accordance with the Title 213, 233C, 213, 235, and frequencies specified for Class 1 track. Guidance. Pursuant to Statute 213.5b, the railroad may continue with the train operation track segments designated accepted track with the complying with the subparts B, C, D, and E of subpart of Part 213. However, the railroad must simply still comply with the inspection requirements found in subpart F of the track segments designated with accepted track. Railroad must inspect the accepted track in accordance with the Statute 213, 233C, and 213 through 35 at a frequency specified for Class 1 track. 4D. The identified segment of the track is not located with the bridge, including the track approaching with a bridge of 100 feet on either side, located on the public street or highway. If the railroad cars containing with the commodities required to put a placard with the hazardous material regulation, Title 49 CFR Part 172, are moved over the track. And the guidance and application paragraph of the public street and highway is defined as the roadway that opens to the public and owned by the maintained and by public entity. This paragraph includes both the crossing and public roads at the grade and longitudinal running of the track of the extended distances of public road street trackage. Title 4 under Title Statute 214.7, the railroad bridge is defined as following. The railroad bridge is a structure supporting one or more of the railroad tracks within a span of 12 feet or more measured along with the track center line. The term bridge should apply with the entire structure between the faces of the back walls, abutments, and equivalent components regardless of the number of the spans. The term shall include all the structures, whether the timber, stone, concrete, metal, or any combination thereof. 4E, the railroad conducts an operation identified segment under the following conditions. 1, there no train shall be operated at a speed in excess of 10 miles an hour. 2, non-occupied passenger trains shall be operated. 3, no freight train shall be operated with containing more than 5 cars required as a placard by hazardous material regulation, Title 49 CFR Part 172, and the gauge expected track should not be more than 4 foot, 10 foot, 10 and a quarter inches. The paragraph E4 of the applicable September 21st, 1999. Guidance. In reference to E1 through E4, the well-documented pattern, the repeated with the widespread deviations from these requirements of the track owner include the train operates in excess of 10 miles an hour with effective terminate, and with the privilege afforded by this section, the effective track would become the subject to all requirements of track safety standards. The word occupied in E2 refers to the paying of the non-paying passengers. It does not include the train crew members, the maintenance crews, and other railroad employees who must have travel over the track to attend their work duties. The gauge requirement only applies to the actual measurement itself and unloaded. It does not extend to the evaluation cross-ties fasteners that provide with the gauge restraint. In the case of the non-compliance with the gauge requirement is accepted to the track, the railroad may invoke the statute 213.9B as a remedial action. See 213.9B for the restrictions. 4F. A track owner shall advise the appropriate FRA regional office at least 10 days prior to the removal of a segment of the track from the expected status. Guidance. The track owner is required to notify appropriately the FRA regional office of 10 days before removing the track from the expected status. The railroad may not move a track from the expected non-expected status to operate with the occupied passenger or train containing more than 5 cars placed in accordance with the Title 49 CFR Part 172 unless proper notification procedures have been followed. Inspectors will continue to inspect expected tracks, report the inspections on Form 96. If serious deficiencies discovered, that will show an inspection by form noting that the track is in expected status. The track owner would not be legally obligated by the track safety standards to correct the deficiencies noted, but they accept the gauge deviations in excess of 4 feet, 10 foot, 10 1/4 inches. However, if the condition of the track continues to constitute the hazard life limit of the track owner and fails to alleviate the hazard, the inspector shall notify the regional track specialist immediately. Issuing of an emergency would be appropriate to address the serious defects that would impose the immediate safety threat of the railroad employees or public. The notification provision is intended to prevent the practice of the FRA has been witnessed in the past of some railroads, specifically those who are removal of the track into the accepted status only belong to move passenger excursion train or train and with more than 5 cars containing the hazardous material. The following examples are provided with the inspector to determine the compliance with the provision of accepted track. Example 1, on January 1st, 1988, a railroad designated 2-mile segment of the yard track in the number 1, which Class 1 track is expected track. The expected track segment is located within 25 feet of the adjacent track, open to simultaneously operations. Speed up to 20 miles an hour are authorized. On January 25th, 1998, the inspector had found 5 locations in the segment at which the Class 1 gauge requirements are not being met. Result, the segment of the yard track number 1 involved with the ineligible designation accepted of the track because of the violation 213.4B simultaneously uses the restriction. Therefore, the segment remains the subject to all the provisions of the track safety standard. The FRA may cite with any of the deviation from the track safety standards discovered with the segment, such as 5-day age defects in the violation. The railroad may also be cited with the FRA inspector discretion for a violation of section 213.4B. The inspector determines the violation are warranted. Normally, the substantive defect of the gauge alignment of the cross ties should be cited. Example 2, the railroad designates a yard as the track number 6 of the Class 5 with the Class 1 expected with the November 30th, 1998. The railroad does not conduct any of the inspections over the track during the December result with the yard track of the number 6 loss of the eligibility designation expected on the track January 1st, 1999 remains ineligible. Therefore, the inspection required in Statute 213.4 begins. Starting on January 1st, 1999, the track becomes the support subject to all the provision of the track safety standard remains subject to all those requirements until such time as the inspection begins. The violation citations arising with the inadvertent violation of the inspection requirements ordinarily should be issued only where the safety was impaired with these evidence continue with the non-compliance. In contrast to the violation of the definitional requirements of the unit, the violation of non-compliance with the operational limits is a train, whether referred to as occasional and inadvertently non-compliance with the operational limits. A persistent, well-documented pattern of non-compliance with respect of the particular segment may cause the railroad to lose its privilege designating of the segment as accepted track, i.e. the track would no longer be qualified for such designations. Or the FRA has used more drastic enforcement remedies such as emergency order. The following examples illustrate this concept. Example 3, the railroad properly designates track segment as accepted track and 10 days later in operating the freight train containing 10 flat car tanker cars over the track segment. Result 1 violation statute 213.483 by the railroad has occurred, not 5 because of the unit violation of the train rather than either the plaque order exceeding of the 5-car limit. The segment continues to be accepted to the track because of the violation and operational limitation does not render the track ineligibility expected track status. Example 4, regional railroad properly designates one of the track segments as expected track. The railroad B with the freight of the freight 2425 using the segment pursuant to the track right agreement. Railroad A operates over the segment at speed 20 miles an hour. Result, one of the violations of statute 213.4E1 of the railroad A, the track owner is the responsibility party for illegal operation over accepted track. The segment continues to be accepted track. 213.5 responsibility for compliance. The 5A exempt for the provided from paragraph B of the section. Any owner of the track in which the part applies and knows that or notices that the track does not comply with the requirements of the part shall 1. Bring the track to compliance. 2. Halt the operation over the track. 3. Operate under the authority of the person designated under statute 213.7A who has the least 1 year of the supervisory experience in railroad track maintenance subject to the conditions set forth in this part. The guidance of the paragraph describes the action that must be taken in the track owner's once and they know that the track is not compliant with the track safety standards. The track owner must 1. Bring the track into compliance either by repairing the defects and posting an appropriate speed restriction. 2. Remove the track from service. 3. Operate under the authority of a qualified person designated under statute 213.7 in accordance with one of the following provisions. 213.9 B. Class of the track 30-day provision. 213.11 restoration renewal of the track under the traffic conditions. Statute 213.113.11.3 rail defects. For additional information concerning the required corrective action of the defects, see the guidance under statute 213N. 9. Class of the track, operating speed, 5B, if the owner of the track to which they apply the designated with the segment of the track, except if the track owner of the provision statute 213.4 operations may continue over the track without complying with the provisions of subpart B, C, D, and E unless otherwise expressly stated. Guidance the owner to designate the track accepted provided that it meets the requirements of statute 213.4. 5C. If the owner of the track to which the parts applies the responsibility for the track to another person or release otherwise, the notification assignment shall be provided with the appropriate FRA regional office at least 30 days in advance of the assignment, and the notification may be made in part of the assignment shall be written in including the following: the name of the address of the track owner, the name and address of the person to whom the responsibility is assigned to, the assigner, the statement of the exact relationship between the track owner and the assigner, the precise identification of the track statement of the competency ability of the assigner to carry out the duties of the track owner under this part. 6. A statement and signed with the assigner acknowledgement of the assignment of him and the responsibility for the purpose of compliance with this part. Guidance in statute 213.5C gives the track owner the responsibility to notify the FRA through the appropriate regional offices with a responsibility for compliance with this part. As assigned notification must contain the specific information required in this paragraph shall be made in 30 days before the assignment of the responsibility. 5D. The administrator may hold back the track owner assigning both the responsibility and compliance with the part of the subject penalty in statute 213.15. Guidance of the section corner situation whether the track is not owned or the operating the railroad with arrangements such as the lease agreement when recommended civil penalties typical operating railroad will be cited. However, it will be appropriate to the recommendation of the civil penalties against the operating railroad. The owner when the poll parties contributed in with the deficiency inspector must determine the responsibility part of the recommended civil penalties for noncompliance with and the alert the FRA chief counsel when violation reports involve the parties other than track owner. The paragraph provides the partial responsibility of the compliance and can be other than the actual owner of the track of the assignment responsibility of Surface Transportation Board, formerly Interstate Commerce Commission, has been issued the direct service order. The FRA may hold responsibility any party that can contracted with the track owner to ensure the compliance with the part. The FRA may hold the track owner and the assigner and both responsible. 5E, the common carrier of the railroad directed with the Surface Transport Board is to provide the surface over the track of another railroad in Title 49 U.S. Standard Code of 11123 is considered by the owner of the track at the purpose of the application during the period of the directed service order remains in effect. Guidance. One of the rare occasions such as necessitation of the service by railroad service the Transportation Board has directed the railroad other than the track owner to provide services. In such case, the designation operation shall be considered as the owner of the purpose of the compliance with the track safety standards. 5F. When any person included with the contract of the railroad track owner performs any of the function required by this part, the person is required to perform the function in accordance with this part. Guidance. The paragraph specifies both employees, railroad, and track owners and contractors of the railroad are subject to requirements of track safety standards when they are performing the project functions required in the track safety standards. 213.7 Designation qualified person to supervise certain renewal air inspections. 7A each of the track owner to which the part applies shall designate a qualified person to supervise the restoration renewal of the track under the track conditions that each person shall designate and have at least one 1. At least 1 year supervisor experience in railroad track maintenance. 2. A combination supervisor experience, track maintenance, and training in the course of the track maintenance for the college level educational program related to track maintenance. 2. The demonstrating to the owner that he or she, 1. knows to understand the requirements of this part. 2. Can effective deviations from those requirements. 3. Can prescribe an appropriate remedial action to correct safety, compensate, and for those deviations. 3. Written authorization from the track owner to prescribe remedial actions to correct and safely compensate with the deviations from the requirements in this part. 7b. Each of the track owners to which the applies to the shall designate qualified person to inspect the track defects. Each person shall have at least 1 year of experience for the railroad track inspection. 2. Combination experience with the track inspection training from the course of the track inspection or from a college level educational program related to the track inspection. 2. Demonstrate the owner that he or she knows under the standing the requirements of this part. 2. Can detect deviations of these requirements. 3. Can prescribe appropriate remedial actions to correct and safely compensate those deviations. Through written authorization for the track owner to prescribe the remedial actions to correct and safely compensate with the deviation requirements of this part, pending the review of the qualified person designated under paragraph A of this section. Guidance inspector may request the track owner with the verification and experience the qualifications of his supervisor and track inspection personnel. Submission of the seniority roster job awarding bulletin and is not to be considered a satisfactory identification qualified employee error as a basis for their designation. The owner should make a specific name the individual qualification available in writing. If the inspector is in doubt of the qualification of own supervisor inspection personnel, the inspector should examine the owner's inspection records. The track safety standards require the retention required for the track inspection report for 1 year of the owner of the division office. So should the records consistently fail to reflect the actual track condition of the question, can be raised to the competency and qualifications of the person included in the list. When in doubt, the qualification of the owner as a supervisor or inspector, the inspector should discuss the matter with the railroad. 7c. The person that had not fully qualified supervisor can certain renewal of the inspection tracks is outlined with the paragraph A and B of this section, but within the last year with one of the maintenance way, signal experiences may pass the train over the broken rails and pull parts of the provided by that. 1. The track owner determines the person qualified as part of the doing so of the train, re-examine the person periodically within 2 years after each of the prior examination following topics as it relates to safe passage of the trains over the broken rails. Or pull apart rail defect and end identification, cross tie condition track surface in alignment with the gauge restraint and the rail end mismatches joint bars. Maximum distance between rail ends over the trains may be allowed to pass. The sole purpose of the examination is to exertion of the person's ability to effectively apply those requirements of the examination may not usually disqualify the person from their other duties. Minimum of 4-hour training is adequate for the initial training. 2. The person deems the safety of the train speeding are limited to the maximum of 10 miles an hour over the broken rail or the pullable part. The person 3. The person shall with all the movements of the broken rail pull apart and be prepared to stop the train if necessary. 4. Person fully qualified by the statute 213.7 to the part of the notified dispatch with the location promptly purposely authorizing movement of the affecting temporary with the permanent repairs. Guidance paragraph C allows employees to be qualified for the specific purpose of authorizing train over the broken rail to pull apart. The section required the employees to have at least 1 year maintenance of the way or signal experience and a minimum of 4 years training plus examination. 4 hours of training plus examination requirements related to the safe passage of the train over the broken rails and pull aparts. The purpose of the examination is to association of the person's ability to effectively apply with these requirements. Railroad may use the examination to determine whether or not the person should be allowed to authorize the train movements over the broken rails and pull parts. The maximum speed over the broken rails, pull parts, should not exceed 10 miles an hour. However, the movement authorized by the person qualified under the subsection may further restricted speed if warranted. With particular circumstances, the person qualified under this paragraph must be present in sight with the able to instantly communicate with the train crew so that the movement can be stopped immediately if necessary. Fully qualified person under statute 213.7 must be notified and dispatched with the location promptly to assume the responsibility of the authority authorizing train movements effective repairs. The word promptly means they provided with the railroad the same flexibility in the case that there is only one train to be passed. The condition prior to the time the fully qualified person would report for a regular tour duty where the train is due to pass over the conditions before the fully qualified person is able to report the scene. Railroad should not use the person qualified under statute 213.7c to authorize multiple train movements over such conditions. 7d. When the respective designation under paragraph A, B, and C of the section, each track owner must be written in the records of each designating and the facts and basis of each designation. The track inspection made by each of the designated qualified personnel as required in Statute 213-241. The records must keep them available in the inspection copy in the Federal Railroad Administration during the regular business hours. Guidance: the failure of the owner to have them maintained with the record of the designating employees the basis of each of the designation is a deviation from the track safety standard. The employee incomplete qualification records would also constitute a deviation from the standard. Designated employees include the supervisor and inspectors, those particularly partially qualified to pass the trains over the broken roads and pull the parts. Inspectors are also instructed to note the incomplete qualification records may not reflect the actual qualification of an individual. As such, the record of deficiency shall not be based solely on the basis for the defect from the civil part penalty recommendation for not having the qualified designated person perform these functions. If there is a question of the qualification of an individual, it will be necessary for the inspector to interview the railroad and contractor employees. 213.9 Classes of track operating speed limits. 9A, except for provided with the paragraph B of the section 213.57B, 213.59A, 213.113A, 213.137B, and C, the following maximal allowable speeds apply. Over the track means of the expected of the parts in the parts exempted. Maximum allowable speed of 10. Maximum passenger train not applicable. The over the track that over the track that meets the requirements prescribed in this part of 1, maximum 10 speed, 15 for the passenger. 2, 25 miles an hour freight, 30 passenger. 3, 40, 60 passenger. 4, 60 freight, 80 passenger. 5, 80 freight, 90 passenger. Guidance: the track safety standards classify the solely basis of authorized speed for the freight and the passenger train tolerance are specified in the track safety standard for each of the classes of the track. A deviation beyond the limiting tolerance of the class 1 through 5 requires the preparer's reduction in the speed of the appropriate class. The only structural geometry defect of the applicable on the expected track gauge exceeding with the 4 foot 10 1/4 inches. The initial speed of ending the track based on the design characteristics of the track. The FRA does not set the speed. Railroads are not required to keep the track in compliance with the requirements of Part 213. In addition, with the track designated characteristic speeds may be set by other factors such as the type of signal apparatus and make speed of the also limited in signal system, and if not in place of the track, refer to Title 49 CFR 236.0 further information. And if the deviation of Class 1 standards operation may continue for not more than 30 days off of the deviation not exceeding Class 1 speeds, this is only permitted after the person designated in Statute 213.7A within the last 1 year. The supervisor and experience in a railroad track maintenance determines the operation may safely continue, specifically limiting the condition, if any, the designated person must have a personally seen and evaluated deviation. The section may also govern the deviation exceeding the allowable the gauge and accepted track. It is described in paragraph A. The maximum allowable operating speed for each class of the track is shown in the table. However, the maximum allowable operating speed on a curve is limited to geometry parameters contained in Statute 213.57B and unbalanced in 213.59A and super elevation. For example, the speed passenger train based on the elevation curve may only be 18 miles an hour, even though the track may otherwise comply with the higher class. One of the loose frog bolts over the outset several would the seldom constitute with the an immediate hazard. Provided with the frog was otherwise secure, the other hand of the missing cotter pin of the critical pin location, such as a connecting rod, could have serious consequences. 1 or 2 loops braces are usually not considered to be an immediately hazard, provided with the other braces in unacceptable functional condition. Support stock rail. On the other hand, the several consecutive loss of loose braces, especially in the higher track classes, and could be more serious. Intermittent patches of vegetation, brush sides of the rolling stock may not be an immediate hazard, but most severe vegetation may have a potential contributing injury to an employee who's riding on the side of the car looking at the locomotive cab, the window, specific description, the type of the defect, vegetation, brushing side of the rolling stock to prevent the employees from visually inspecting moving the equipment from the normal duty stations. As above, the example illustrates the non-classic specific defects that must be considered in the context of specific circumstances involved with the existing non-classic classes. A specific defect under one set of circumstances may not be serious. The identical condition under other circumstances may constitute serious safety concerns. Although some of the non-specific defects may not present an immediately hazard, these conditions are only degrade the train traffic. Therefore, it is important for the carrier and the FRA inspector to record these defects so that they will not be left unrepaired. In summary, 1. Recording all non-compliant conditions, including non-class specific defects such as the loose missing frog bolts or switch braces. Carrier must be taken with the conducting through a inspection regarding recording the location, type, and the size of the defect discovered. 2. The evaluated remedial action taken by the carrier. If the inspector becomes aware of the remedial action and lack thereof, the non-class specific defect is not sufficient based on the circumstances, the inspector should seek more appropriate action, such as the carrier. For non-class specific defect and imminent hazard, such as a missing nut of the connection rod, the inspector should immediately inquire remedial action plan with the carrier. 3. If the railroad does not initiate the appropriate remedial action, the inspector should consider the recommendation of violation. The railroad has been advised that the violation has been recommended and has been not initiated the appropriate remedial action. The inspector should be prepared with a special notice for repairs under the guidelines prescribed in Chapter 4 of this manual. In the case of a non-class specific defect that did not pose an immediate hazard when the defect is recorded, the inspector discovers no action was taken responsible time frame and the carrier had an acknowledgement of the defect. The carrier should consider the enforcement operations described in Item 3, and in any case if no appropriate action was taken in the 30-day period, the inspector should consider the enforcement tools outlined above. When the railroad inspector discovered the non-class specific defects as well as all the defects, the railroad inspector must initiate the immediate action in accordance with the statute 213-233D. The remedial action taken with the railroad inspector must record in accordance with the statute 213-241B. For no specific defects, the record must be shown the reasonable explanation for the action taken. For example, the repaired before the next train was appropriate for the serious condition. On the other hand, the notation of the defect, such as vegetation, that indicates the schedule for the cutting of the weed mower, the specific date of 30 days may be appropriate. When railroad representative places a slow order segment of the track, the defect for the immediate corrective action, any of the others with the same slow the segment would be protected. For example, the FRA inspector finds the defects in MP milepost 5.5. Railroad immediately places a slow order on milepost 5.5 through milepost 6. During the same inspection, the FRA inspector also finds the condition of the milepost 5.8, and that would be defective without a speed restriction, while the defect of the milepost 5.8 is under slow order just imposed. The obviously defect prior to the placement of the temporary restriction. The FRA inspector can record the defect of milepost 5.8. Alright, a non-class specific defect of making pose the immediate hazard over the one train, but the condition may deteriorate to become the hazard from the following points. Reasonable exemption conditions such as loose missing frog bolts braces be repaired quickly as possible. However, the qualified railroad representative under statute 213.7 may determine that the condition is not an immediate hazard, decide to call the assistance to make sure the repairs. The representative may decide to the end of the inspection retrieve the necessary repair materials, return later to make the repairs. In some cases, the representative may determine the speed restriction is appropriate. When non-class speed defects are scheduled for the repair and railroad inspection shall continue with the report of the defect on their inspection reports until it is corrected. However, the 30-day limit for any of the given defective conditions cannot exceed. 9b. If the segment does not meet all the requirements intended for the class, if in reclassification, the new lowest class of the track would determine to meet the requirements of the part. However, the segment of the track does not at least meet the requirements of Class 1 track. Operations may continue Class 1 speed for the period of not more than 30 days without bringing the track into compliance under the authority of the person designated under Statute 213.7a, who has at least 1 year of supervisor experience with the railroad track maintenance. After this person is designated, that operations may safely continue subject to any limited conditions specified in such person. Guidance. The track segment must meet all the requirements of the designated class. Where the track segment does not meet all the requirements, railroads are reclassified the segment in the slowest class, which complies with, for example, the Class 3, where alignment measured with the 60-foot to chord in the tangent 2 inches. The railroad can elect to reduce the speed equivalent to Class 2 track. The train may continue to operate in non-compliant conditions over the statute 213.9b. However, there are 30-day limitation for any given condition cannot be exceeded. 30-day period commences when a FRA inspector notifies the carrier and issues a notice for the Form 96. The person designated in Statute 213.7 recorded the defect from the track owner's record, and the inspection notice of the substandard conditions are received in third parties. Or the track owner is deemed to have the constructive knowledge of the defects where the discovery through the properly performed track inspection required by the track safety standards, even if the defects are not reported with the owner's recorded inspection. Several other points of concern of the Statute 213.9b should be noted. The FRA inspector should be not attempting to predict the exact date of the subclass 1 defects first existed. In most cases, reasonable approximation with the accompanying explanation of the base of the inspector conclusion, while sufficient to show that the statute 239AB is not available to the track owner because of the serious enforcement problems presented with the application of constructive knowledge test, the inspector should be easily thwarted judiciously. Once the determination has been made with the operation making safely continuing over the segment, the 30-day period applies to all subclass 1 defects. Presently, the segment of it all the time. The 30-day period is appropriate remedial action for the subclass 1 of the defects. The 30-day period can only be applied at one time. For the expiration of the 30-day period, defects must be repaired on the track, placed on the accepted track status, and the track must be removed from service. Limitations condition, if any, of the place in the operation must be in the formerly generally used. The track owner communicating operational restriction to its personnel to any of the other railroads authorized to use the track involved. If the train operating over the track fails to comply with any such condition, one violation of statute 239B, the track owner has occupied regardless of identifying the operator of the train. Section 239B does not apply where the defective railroads are involved. The section 213-113B exclusive governs further operation over defective rails. The following table shows the example of section track safety standards that are class-specific, speed-defined, or non-class-specific. These tables are not inclusive and only with the reference instruction. Inspectors should refer to the specific guidance under each of these sections and for the further details instruction each of the items listed in the table. Drainage and vegetation is non-class specific. Curves and elevation, speed limitations, and speed defined. Ballast in general is non-class specific. Cross ties are non-effective distributed, non-class specific. Gauge restraint measurement system, the class specific. Defective rails are speed defined. Continuous welded rail, general, non-class specific. Each rail insulated with an uncompromising joint shall be structurally sound, dimension for the rail on which it is applied, non-class specific. If the joint bar is cracked or broken between the middle two bolts and it shall be replaced as class specific. In the case of the conventional jack joint track, and each whether shall be bolted and with at least one bolt in class 1 track, the class specific. In the case of a continuous welded railroad track, each shall be bolted with at least 2 bolts at each joint. That's 3 class specific. Alright, each joint bar shall be held in position with the track bolt tightened to allow the joint bars to firmly support the abutting ends. That is a non-specific class specific. Turnouts and track crossings generally are non-class specific. Class 3 through 5 should be equipped with the anchors of each of the side of the track and crossing with the turnouts are specified. And in each of the flangeway of the turnouts, track crossing shall be at least 1.5 inches wide. That's class specific. Each of the stock rails may securely be seated in switch plates. That's not class specific. Each switch point shall fit in its stock rail that is speed defined and non-class specific. The following. Each switch was maintained with the outer edge of the wheel tread cannot contact with the gauge of the side of the stock rail. That's class specific. Heels of each switch of the rail shall be secured. Class specific. Heel of each switch stand on the connection rod will be securely fastened. Class specific. Each throw lever shall be maintained so that it cannot be operated by the lock of the keeper in place. Non-class specific. Switch position indicator non-class specific, usually worn and chip switch points. Non-class specific. Tongue and plane mated switch is class specific. If the frog point chips are broken or worn more than 5/8 of an inch down or 6 inches back, operating speed over the frog may not be more than 10 miles an hour. Speed refined. If the tread portion of the frog casting is worn down more than 3/8 of an inch below the original contour, operating speed over the frog may not be more than 10 miles an hour. That's speed specific. Alright, the outer edge of the wheel shall not contact the gauge of the spring wire, spring wing rail at non-class specific. The toe of each of the wing shall be solidly tampered with non-class specific. Each frog hole bolt, defective head web separation shall be replaced. Class specific. Each spring will have the compression. Non-class specific. The clearance between the hold down and housing of the horn is non-class specific. Self-guarded frogs are class specific, and derails are non-class specific. That was table 2. Trying to look for subpart B or subpart B. 213.11 Restoration and renewal of the track under the traffic condition. If during the restraint of the renewal of the traffic under the traffic conditions does not meet the all requirements prescribed in the part, the working on the track shall be under the continuous supervision of a person designated under statute 213.7a, who has at least 1 year of the supervisor experience with the railroad track as maintenance, with the subject to any limitation conditions specified by such a person. The term of the continuous supervision you're using the section means the physical presence of the person at the job site. However, the say, the work may be performed on a very large area that's not necessary for each of the phase of the work to be under the visual supervision of that person. Guidance: the section specified by the person designated under statute 213.7a must provide with the continuous supervision during the work of the period of the track conditions not complying with the designation of the class under the track condition. In addition, the track this section specifies that each of the phases of the restoration renewal needed not to be under the visual supervision of the person, but the person must be present at the job site in the direct control of the work and have the direct knowledge of the condition of the track over which they permit a train to pass. Train or trains to pass. The qualified person at the work site may determine if the say to train pass through the work area at the speed of the permanent speed of the track, and for example, during the cross-tie resurfacing project, qualified persons may analyze the condition presently authorized speed higher than 10 miles an hour for those through limits of the work through the temporary cost level of the conditions existing heating limits in statute 213.63 for class 1 track. Similarly, the welder may not permit the welder may permit the train to pass over the frog when the welding of the grinding process temporarily removes the point more than 6 inches back and the 5/8 of an inch down. At the end of the work period, the designated person leaves the work site. The track must be in compliance with the track safety standards and acceptance, with the designated person determined with the track safety operation of the class 1 speed of the using the 239B with the remedial action. Continuous supervision must be met if the work in the broken into the number of segments over the large area. The inspector should judgment and experience with the and applying with the limitation of the general rule. The essential qualifications are the specific circumstances of the given the projection actual permanent effect of the supervision by the designated person, whether the source of the supervision is being properly exercised. Example: acceptable application for the paragraph would be large tie surface using unit while the cleared track of the short period allowed the passage of the train path. Based on the qualified person determining the track of the safe operation. On the other hand, the switch gang was working separately from the tie of the surface of the crew with the same general vicinity of the qualified person must be in the work unit. I'm sorry, I had to fix something. When unlocked, alright, 213.13 measuring track not under the load. When unloaded, a track of the measure to determine the compliance with the requirements of this part, the amount of the rail movement, if any of the occurs but the track is loaded, must be added with the measurement unloading the track. The guidance, in addition with the static unloaded with the geometry measurements to take an amount of the visually detectable dynamic loaded deflection of the curves under the train movement must be considered, but include the amount of the vertical lateral rail deflection occurring between the rail and the base and the tie plate cross tie, the voids between the cross tie ballast section resulting from the elastic compression of any of the combination of the above. Each of the deflection under the running of the rails must be measured properly, considered with the computing and collective deviations under the load. Is very important, but the consideration to be given with the both rails when measuring these conditions. Vertical lateral deflection may be found in location such as rail joints, turnout with location poor wooden cross ties, conventional cut space fastening conditions added with bridge abutment and other over cultivars with subgrade has been met. 213.15, the penalties. 15A, any person who violates the requirements of these parts because of the violation of any such requirement subject to civil penalty at least $500, not more than $11,000 per violation, except if the penalties may be assessed against individuals only where willful violations and grossly negligent violation of the pattern repeated violations has created imminent hazard of death and injury to the person has caused death and injury penalty not to cover the exceeding $22,000 per violation may be assessed. Person may means of entity and other type covered under Title 1 U.S. Standard Code 1, including but not limited to the following: railroad manager, supervisor, official, other employee, agent of the railroad, any owner of the manufacturer, leaser, lessor of the railroad equipment, tractor and facility, tracker facilities, independent contractor providing with the goods and services of the railroad, an employee of such owner, manufacturer, lessor, or leaser, independent with the contractor, any one of the Federal Railroad Administrators responsible for the title of Statute 213.5D, 213.303. Each of the day violation continues should continue constitutes a separate offense. See Appendix B for these part. The statement of the agency civil penalty as in policy. B. Any person knowingly, willfully falsifies the record and reported required for these part of the subject to criminal penalties under Title 49 U.S. Standard Code 213111. The section covers the subparts of Part 213, including the schedule of civil penalties under Part Annex B of this manual. 213.17 waivers. 17A. The owner of the track in which the applies with any other person subject to the part may be in petition of the Federal Railroad Administration for the waiver from any of the requirements prescribed in this part. The fitting of the filing of such of the petition does not affect the person the responsibility for the compliance with the requirement while the petition is being considered. Guidance. Inspectors have no authority under the track safety standards. The gear waiver, the 17B, the petition waiver under the section must be filed in the manner of the containing the information required in Part 211 of this chapter. The guidance, any petition waiver must be filled with the owner and the designation operator with a document-created clerk, office of the Chief Counsel of the Washington, D.C. Refer to the General Manual for complete information regarding the waiver procedure. 17C. The administrator finds the waiver in the public interest consistent with the railroad safety. The administrator may grant the exemption subject to any of the conditions that the administrator deems necessary where the waiver is granted, but the administrator publishes the notice containing the reason for the granting of the waiver. Guidance. Inspector must be notified of any of the waivers in effect with the assigned territory. 213.19. Information collection. 19A. The information collection requirement is part of the review of the Office of the Management and the Budget pursuant to the Paperwork Reduction Act of 1980, Total for U.S. Standard Code 30501, a sequence, and also are signed in Office of Management and Budget Control Number 2130-00110. And then it goes into collections. Subpart B, roadbed.